Thank you, Ms. Munsingha. Now, we have here three eminent personalities from your own faculty. They are all teachers. Now, in between there are your Dean of the Faculty is here, and the senior, some lecturers are here, and including me as your chair. Above us is yours, the student community of this university. So it's time for you to make use of this opportunity. You have heard for the last 2 days eminent speakers giving their thoughts after much research. You can choose your language, I believe, today, or do they have to speak only in English? In any event, please, now all this time, it was only the seniors who spoke most. Take your time. There are 3 different topics were discussed. Take your time. We will until we discuss. Formulate your questions or thoughts and make it short, and get up and ask questions. And also, during our time, when we were law students, we didn't have this type of sessions, academic sessions every year happening. All faculties plus this faculty. So make use of this opportunity. Please go home. Take your day off tomorrow. But Sunday morning, please log on to your website and read 1 or 2 articles fully, other than listening to this. And make sure that you also develop an interest in your military or civil career, that you will develop an interest of doing more research studies. So I think it's time for us, we have a little more time to have a discussion. If you have any questions or clarifications to be made from these eminent speakers, you are free to do so. The mic will be given to you. To start with, yes, there is a student. Please, can you kindly identify yourself first, and the year and the name.
Good evening, ladies and gentlemen. Good evening, Chair and faculty, the Dean of Faculty of Law. I'm Hansini Palagama from the first year. I'm a first year student from Faculty of Law. My question is to the first presenter, ma'am. Ma'am, you spoke of the relationship between doctors and patients, and that it's built on trust. But in a country like Sri Lanka, where a lot of people, we have people who live in rural areas who are very uneducated and who actually see doctors and people in the medical field as gods. I mean, that is the basic concept that people from rural areas have. And because of that concept, which is built by the society since a long time, they sort of refuse to speak up to doctors, and doctors also knowing that, because doctors knowing that they are highly respected, they refuse to show kindness and carry out their ethical conducts when treating patients. I would like to know what sort of remedy would you propose for this, because it's very important that, like you said, that there needs to be a trust built between doctors and patients. Because of this lack of trust between patients, because of the concept that patients have regarding doctors, what do you suggest? Because as patients, we are patients when we go to the doctors. We ourselves see that when we talk to a doctor, we find it really uncomfortable to talk to a doctor about our sickness or our medical requirements, because they sort of do not tend to us kindly, or they do not show that sort of connection with patients. So what kind of remedy do you suggest for this? And how do you think it's practical for us to carry out such a remedy in a country like Sri Lanka, where we live within a certain framework?
Yeah. Actually, first of all, when we are dealing with the problem between doctors and patients, as I explained, we have to identify actually why patients sue. Especially patients sue when there's a communication breakdown between doctors and patients, when their questions goes unanswered and ignored, and when they feel unattended. And the other thing is, doctors normally, the normal tendency of the doctors are to not to reveal too much information and to remain silent. So there's a problem in that sense between doctors and patients. So that's why I explained that there should be even through media or by organizing campaigns or any other used by any other method, we have to raise the awareness of the public. That's the first point that I want to highlight. And the second thing is, when we go through the code of ethics, SLMA code of ethics, when the doctor has acted with professional negligence, there are remedies under the code of ethics. So according to the code of ethics, care and attention which is needed to be given by a doctor is a comparable one, which is in an equivalent standing. So according to the code of ethics, SLMA code of ethics, they can take disciplinary action, and also they can erase the name from their register if they are acting with negligence. So that's true. As you mentioned, there's no adequate discussion between the doctors and patients. That's why I explained that basically we have to address that issue. We have to take steps to educate the public, and we should take steps to strengthen the relationship between the doctors and patients. So I think rather than going for court litigation, mediation, that's why I highlighted that mediation is a best platform to open exchange of information. Because when doctors are in a highly litigious environment, they tend to take defensive actions, and also they will avoid highly risky patients. So those kind of disadvantages can be reduced by introducing such kind of methods, because through mediation, both the parties can face-to-face discuss the emotional aspects of their problem, and they can come to a conclusion which address both parties' concerns. That's why I explained that rather than going for arbitration and the other ADRs, mediation is the best method that we can use, and also which are using in other countries such as UK, USA and Australia, as the best solution to address the unique characteristic between the doctors and patients. And also I want to say that historically doctor-patient relationship is placed in a very higher place, but now the distrust is becoming increased between the doctors, because doctors are considering patients as another client, and the patients consider, on the other hand, patients consider a doctor as a service provider. So the distrust is becoming increased between the doctors and patients because in today's society. So I think mediation can be used to address this solution, especially to address the unique characteristics between the doctors and doctor-patient relationship.
Thank you. Ms. Dayaratna, you have in your presentation, during this presentation, you have mentioned about the case, that is Riyansi Asakuratna versus Priyani Soisa. As we all know that it had gone on to 3 different stages. One is the district court. In the district court, the negligence was proved, judgment was given in that basis, and the damages was awarded. In the court of appeal, the damages part was taken off because the father who sued was not dependent. Because in Sri Lanka, to make a claim, you have to say that you have been, because that is not the victim, that is the victim's father. He was not dependent on, therefore that part was taken off. In the Supreme Court stage, the negligence also was taken off because it was established that at the evidence stage in the district court that they have proved that the best medical care was provided to the patient. So actually, to win a case or to do successfully a medical negligence case, you need to lead the evidence of an expert, and that is from the plaintiff side, from the victim side, or the victim's dependent side. on the other side, that is the defendant, that is the medical practitioner, will have to, other than her own evidence and the medical bed etiquette, will have to lead the evidence of another expert or from a textbook to say that best medical care which was taught to her had been reproduced to this patient. So that is the criteria. You have to have your best evidence, because even though the evidence ordinance says that no number of particular witnesses are required to prove a point, you have to decide when you are doing a case whether how much of evidence and whether there is particular specific evidence of that. And at the same time, in England and other countries, there is because of these medical negligence cases, there is a practice of narrating down everything that the doctor had practiced on the patient on the bed etiquette. It's like that entire textbooks were written. I don't think that is because of the medical negligence to say that I have done these tests on this patient. Is it necessary for a doctor to reproduce all that medical teaching that he was taught to him in the book? No, I don't think. You have to say that I have treated to the particular year. So that is because of these medical negligence cases. Because of that, what they do is they cut and paste, because they do everything on the computer. They do cut and paste. And at the same time, in those countries, England, America and Australia, the doctor, nobody can just go and see a specialist. First of all, they have to go to a general practitioner, and when the general practitioner refers you to a particular specialist, there is a combination between you, the patient, or the patient next friend, the doctor and the specialist. There is a line of communication. So that line of communication is very important. In Sri Lanka, what they do is they go and see the patient during daytime and scribble something on the bed etiquette and go. The next doctor just go through that. They don't have, as you mentioned, among them there is no discussion. If they do discuss by eye to eye, at least over the phone, among the doctors and the paramedics who have attended to the patient, there would have been a different scenario with the patient. Thank you very much. If there are any other comments? Kamini, you want to?
One cannot resort to arbitration unless you have a arbitration clause in an arbitration agreement. So the patient and the doctor should have an agreement, and the arbitration clause should be in writing. It can be by way of a letter, by way of an agreement, or any other telecommunication method. Mediation, yes, but then you will need to have mediation cells in the hospitals. Otherwise, I don't think the doctors will come to the mediation centers in the island. In Colombo, you have only one mediation center. And in Galle, Mathura, in each district, you have a mediation center. I don't think the doctors will attend due to their busy schedules. They will attend to these mediation sessions at the mediation centers unless you have a dispute resolution mechanism in the hospitals.
Yeah, that's true, ma'am.
Yeah.
As I explained, I think that's true. There should be arbitration clause in the agreement if they want to go for arbitration. My concern is that arbitration is not the most suitable method, because it is also there's an arbitrator in the arbitration procedure, and based on facts and law, arbitrator gives the decision and it is binding and no way to appeal. And even though the parties are frustrated, they can't appeal, and there's no requirement of proving the basis of the decision. So I think arbitration is not the most suitable method, but there are countries such as USA, they are using arbitration. And with regard to mediation, that's true. There's only one arbitration center. If you are going for such kind of a resolution, mediation, I think rather than going for court litigation, doctors will embrace mediation methods, because there are disadvantages of court litigation for both parties, I think. waste of time, waste of resources, and also waste of money. And the other thing is it will have a detrimental effect over the doctor's reputation, practice, credibility, and the self-esteem. And the other thing is when they are in a highly litigious environment, they will take defensive methods. They will take defensive action. So I think rather than going for court litigation, for a relationship such as doctor-patient relationship, if we facilitate the other infrastructure and the other things, mediation is the best method to address those issues in between doctors and patients. Yeah.
So that I think presenter number one, I think in your speech, then when you do the further research, please include the similar things, forums available in that.
Yeah.
I think Dr.
Yeah,
Pratibha
now,
Hana has a suggestion or a question.
Basically, country like Sri Lanka, still doctor autonomy. It has to be changed to patient autonomy. For that we need very powerful patient protection organizations. Trade unions are very powerful in the health sector. But health sector, we can't see any movement which are talking even any type of protection for the patients. But 2003, Consumer Protection Act, there is a clause. Today, even for negligence, you can go to Consumer Affairs Council, legal service, medical, accountancy. That solution, even we are not much using. Because 2003 Consumer Protection, Consumer Affairs Council Act, you can, if there is any type of negligence, no need to go to courts, no need to hire President Counsel, but simply.
Any litigation is good.
Yeah, for you it's good.
I'm sorry.
No, he's a very good lawyer, right? So what we do, I think that also a little bit concerned.
Yes, sir. In South Africa, even under the 2008 Act, it is covered by the product liability scheme. When the medicine which is given by the doctors when the patient can prove that those medicine are defective, that can be covered under the product liability scheme under the Consumer Protection Act, even in South Africa.
Ms. Munasinghe, you are not being left out, but I think the subject that you spoke is about the absolute protection to the disabled children, and also you have spoken on the subject of domestic violence law. But in Sri Lanka, there are, if you see, I am also a trustee of one of the things called Maitri Lama Niwas here. We are getting a lot of disabled children being badly treated by their own parents. How? Do you think that the law as it stands today is sufficient enough, or there should be some more development?
Yeah, sure. Thank you for the question. What I suggest is, right, we have two phases. We have one phase on the other, domestic violence law, and on the other hand, we have enacted but non-operative law relating to disabled person act, which is passed by the parliament, but still it's not in activation. But for theoretically, yes, if you link the two things and get together, combine and get a picture, then theoretically yes. And on the other hand, we have the national policy on relation to the disabled right. It does indicate all the aspects, not only the children, but all the aspects, even housing, nutrition, security, education, and any other related matters. Not for the children, but for the specific categories, women, children, and then the other vulnerable people. And when it comes to disability, you have different kind of people with different angle disabilities. Maybe you have a speaking issue. Maybe you have a hearing issue. Still, you are subjected to the category of the disability under the disability law in Sri Lanka. But how you are going to link these two is an issue. Whether you are going to link this with together and get combined as we know, the student knows about the rules of interpretation and all that, you got together and read with, yes, we have sound. But in individual sense, the Prevention of Domestic Violence Act is just an independent body. It governs an independent mechanism, independent rules and procedures, which is still in a doubt place in case of applicability. And therefore, I think theoretically, yes, but when it comes to practically, it's not much popular.
Ms. Mudrige, you are left out because of the lack of time. Otherwise, I have a question. I will do it later. Now we have to conclude because every good thing must come to an end. Thank you very much for inviting me to chair this session, and thank you very much for the nice presentation. I will also log into your website on Monday morning and Monday evening. I'll read your presentations. Thank you very much for the wonderful audience, and thank you very much for participating actively, and you all must do so. Thank you very much, Dr. Pratibha Mahanameheva, for inviting me. And
thank you, Chairperson. Thank you, sir, for that for a productive session, and thank you for the speakers. Now I would like to call upon the chair to award the certificates to the speakers. Ms. Tilni Dayaratna. Ms. N. Mudalige. Mrs. M.R.I.K. Munasinghe. Thank you, sir. Our Honorable Chair has devoted his time today to be here throughout the day, and he has contributed. I would like to call upon the Rector of the Southern Campus, Brigadier Lal Gunasekara, to give a token of appreciation in appreciation of his contribution. On the stage, sir, to give the tokens of appreciation for the evaluators of our sessions who have kindly agreed to come and evaluate the technical sessions on law. Ms. Samanthi Jayamanna. Madam, please accept our token of appreciation in appreciation of your time and effort. Thank you. Ms. Kamini Disanayaka. Thank you, sir. I'd like to kindly invite you to the mini auditorium in order to conclude the sessions of the day and conclude the law sessions of the International Research Conference. Thank you.